A warm welcome to the sixth edition of Virtual Moot Court Competition conducted by Thomas George and Associate. My name is Gurujala Vishnushree and I'll be acting as the court master for this session. Before we begin, I request all the participants to keep their cameras on throughout the proceedings and ensure that any technical issues are communicated through the chat box. Now, I have the honor of introducing Honorable Judge Advocate Divya Nalla, who will be presiding over today's proceedings. Advocate Divya Nalla is a qualified legal professional practicing in Hyderabad, Telangana. She possesses a robust academic background, having completed both a BA LLB and an LLM from Osmania University, PG College of Law, Bashirbagh. This dual qualification provides her with a comprehensive understanding of legal principles and jurisprudence essential for effective practice. As a practicing advocate, Advocate Nalla is actively involved in litigation and client representation. Her scope of appearance includes the Honorable High Court of State of Telangana and various subordinate courts. Ma'am's professional practice is focused on key areas of law, especially handling matters related to civil law, criminal law, and legal drafting. Ma'am is committed to delivering strategic representations and comprehensive legal consultation while upholding the highest standards of professional ethics and diligence. Advocate Nalla's professional dedication extends to meticulous legal research, providing focused client counseling, and performing essential legal support work. These activities are integral to her ability to formulate effective legal strategies and ensure that her clients receive well-prepared and thorough legal services across their engagements. We thank your Lordship for your valuable time and efforts in adjudicating this session.
Thank you, Vishnupriya.
I will now proceed with the rules. Each team shall have a total of 30 minutes. Each speaker is expected to speak for 15 minutes, subject to extension at the discretion of Honorable Judge. I humbly request your Lordship not to grant any extensions of time due to fixed schedule. As a court master, As a court master, I'll be strictly monitoring the watch. The structure of today's proceedings is as follows. Counsel 1 and Counsel 2 of the appellate side will present their arguments first. This will be followed by Counsel 1 and 2 of the respondent side, with a reply by only one speaker by the appellant and a reply to reply with the judge's discretion. All the participants must maintain a stable internet connection throughout the session. Judgments referred to during arguments may be screen shared with prior permission. In case any participant faces an internet interruption, an additional 5 minutes may be granted, subject entirely to the discretion of the Honorable Judge. To assist speakers in keeping time, placards will be shown when 3 minutes are left, 1 minute is left, and when time is up. Now, appearing for the appellant is team code TGA 26 and appearing for the respondent is team code TGA 9. Wishing all the participants all the best. The court is in session now. TGA 9. Counsels for appellate side.
We are respondent.
The other side for the
TGA 26.
Yes, shall I proceed?
Yeah, you can.
Good morning. The council seeks permission to address the bench as your ladyship.
Yes, you may proceed. Yes.
Much obliged, your ladyship. I, Khushi Chaurasia, along with my co-counsel Ujjwal Raj, appearing on the behalf of appellant ABC Bank, appearing on the behalf of appellant that is ABC Bank, the appeal which arises from the concurrent order of NCLT and NCLAT rejecting the appellant's second application under the Section 7 of Insolvency and Bankruptcy Code, hereinafter referred as IBC, which concerns the two issue, which is the applicability of the res judicata under the IBC and the statutory requirement under the Section 7. Before proceeding, I'll briefly submit the jurisdiction sanctioned it by the statement of the fact, unless your ladyship wish otherwise.
Go with the facts.
Much obliged. Shall I proceed with the facts or the jurisdiction?
Yes, yes.
Okay. This honorable court has the jurisdiction under the section 62 of IBC Code 2016, which explicitly permits an appeal on question of law from an order of honorable NCLAT. Therefore, this appeal squarely falls within the jurisdiction of this honorable court. The council seeks permission to proceed with the facts of the case.
Yes.
ABC, the ABC Bank, the appellant sanctioned the credit facility of rupee 500 crore to the respondent XYZ. The respondent defaulted and the account was classified as the NPA in the year 2014. Between the 2014 and 2022, multiple OTS, which is one-time structuring of the debt, was sent by the respondent to the appellant, acknowledging the liability each time. The one of the such OTS was sanctioned in the year 2020, but the respondent again defaulted on the same, and it was leading to the cancellation of the OTS in the May 2020. The appellant filed the first section. The appellant further filed the first Section 7 application in the year 2022, mentioning the date of default as 2020. The default date, since the date fall within the 10A moratorium period, NCLAT dismissed it, and the NCLT dismissed it, and the NCLAT reaffirmed this. A second application under the Section 7 of IBC was filed in the year 2024, mentioning the date of default as 2014, which was supported by all the acknowledgement, which is the OTS. NCLT and NCLAT dismissed it on the grounds of res judicata and the changing date of default. The appellant is now before the honorable court in the appeal. The council seeks permission to proceed with the first issue, which is framed before this honorable bench.
Okay.
The first issue is whether the second application under the Section 7 is barred by the law or not. The first application, which was filed in the year 2022, it was merely dismissed on the ground because the date of default was falling within the square of the 10A moratorium window period, during which it states that no application whatsoever shall ever be filed for defaults occurring during this period. Thus, the dismissal was not statute, not automatic, and not adjudicatory in nature, because to attract the res judicata, the matter should be heard, examined, and decided on merits. But this never happened in our case because there was no examination of the bank record, there was no verification of the acknowledgement, there were no acknowledgement of the liability on the part of the respondent. Thus, the first application should not be seen as a petition, and time and again, the Supreme Court of India has made the law very crystal clear that dismissal on the procedural and technical ground is not equal to res judicata, as held in the Amradin Ansari versus Afzal Ali and Satyadin Gosal versus Deojan Devai, respectively in the year 2025 and 1916, that a dismissal for an order for dismissal is not equal to a judgment, and therefore we should not count it as one. Section 10A is not allowed for Section 10A does not allow hearing and the deciding of the case. It is rather the freezing of the jurisdiction. Thus, this is a jurisdictional error. Further, the statute itself never mention it anywhere that the second application is barred by the law. Further, I would like to come to a point, the legislative intent behind that statute, that IBC is beneficial and remedial legislation. Procedural defects in it should not eclipse the substantial right, as held in IBIX, Singapore versus COC Educom, and Swiss Ribbon versus Union of India in 2019. This is not an adversarial litigation. It's a economic rescue mechanism for the creditors. If we time and again we dismiss the case just because of the technicalities like date changing or earlier dismissal under Section 10, it would just lead to the corporate debtor would just benefit from the technical gains of the statute, and the creditor the corporate creditors would be just punished for the statutory bars, and which is not right, which is the violative of the rights. Further, I would like to tell this key the default was continuing in nature, so the respondent side itself, they themselves contend in their memos point 2.2 that 10A is to be not applied on the appellant side, which is very much evident, and it contradict themselves too. The council now seeks permission to proceed with the issue 2 if the bench don't have any query for the council.
Yes, yes.
Proceed.
You may proceed.
Much obliged, your ladyship. the second issue is pertaining to the mentioning a specific date of default, whether it is it mandatory or not. So starting with it, the statute itself never mandate a specific default date. The section 3 subclause 12 of the defines default as something non-payment of the debt when the whole or any part has become due and payable. The definition does not require a very rigid date, or like or even it doesn't mention it anywhere that even a mere wrong mention of a date will be this fatal, so that it will lead to the violation of the creditor rights in so many ways that the creditor is not even able to reconstruct their own debt. So this law that requires a default, not a proper paperwork to initiate a CIRP proceeding. Again, the Honorable Supreme Court in the innovative, it is held that the only trigger point to start a CIRP process is the existence of a default, which is clearly time and again and again was also acknowledged by the respondent, followed by the repeated OTS. Not the exact date which is type on the form 1. Form 1 is rather a directionary rather than the mandate of the whole process, because the whole process is not just about the procedural technicalities. It is rather about working in the best interest of both the parties, that is debtor and the creditor. Even if, and a very important point to mention here, and it is very pertinent to know this, even if the information utility record is not mandatory as held in Vijay Kumar Singhania versus Bank of Baroda, then surely we can say, assume it very safely, that a wrong type or wrong mentioned date cannot defeat a very valid application. And this also goes against the spirit of justice. To continue with, the documentary evidence again and again established the fact that there was a default irrespective of the date mentioned. The NPA in 2014, the OTS sanction in 2020, the multiple OTS sent even after the 10A period was over. No repayment even after so much struggle. Your ladyship, this fact is overwhelming of a proof that the default was there regardless of the fact that what the date was mentioned in the form 1. The respondent themselves never disputed the debt or non-payment of it. They themselves agree that yes, they themselves acknowledge the fact, yes, the debt was there, but they were wrong on their part to not pay for it and to not to default again and again on the same part. It is also pertinent to note that NCLT and NCLAT, in so many precedents of them, theirs had said that date of default is not mandatory in nature. For example, Susma Pranjapai versus Rohan Developers 2023, it was held that date in the form 1 is not binding. The court must examine the substance of the case. And rather than going into the technicalities, they should see the substance of the case, which was never done in our case, because the case was just dismissed on the face of it just because it has a particular date mentioned of it. It is on the part of the adjudicating authority to set a date of default, which is a date of default if the appellant has erred on their part, to set a date of default which is in the best interest of both the parties. Further, it was held in Jocon Infra versus Bridge Gopal that the petition was admitted without a specific default date being mentioned. To continue with it, the IBC form which mentioned the date of default, form 1, it is directionary in nature and not mandatory. Form 1 is only a procedural template. It cannot override Section 7, Section 3, subclause 12, economic justice, and the Supreme Court's very own substance over form approach. We cannot just go into the technicalities and ignore the other part of the substance of the case, because that goes against the spirit of justice, and that goes against the how market works and how market regulate itself. Further, the respondent's argument that a wrong date of default is on whims and fancies is not true, because how come a default become no default just because of a clerical error? How is that not against the how is that not against the corporate creditor? Because in this way, again and again, if is this case just being upheld by this, just because thus just being stuck to the technicality of the case, just being stuck to the uh, default date, it can also means that the in the upcoming time, the party will take this as a chance, take this as a opportunity to just escape from the liability, to just escape from the debt, and it will just collapse the whole structure which is set up in the economy, and ultimately creating a unstable environment in the economy, which is not good for it, because the creditor are only there to provide for the debtors. They are there to facilitate them, and not to to get into a long litigation of to to a long litigation to claim their rights again and again, just because of a statutory bar, which the respondent itself claims that it does not apply to us. In their memo, they have clearly mentioned it in the point 2.2. With that, your lordship, I conclude my summation on the issue 1 and 2. I now respectfully hand over the remaining issue, that is issue 3 and 4, to my co-counsel. Much obliged, your ladyship.
Okay.
With, अच्छे से बोला था मैंने, मुझे इन्हें पढ़ने में समझ ही नहीं आ रही थी तुम्हें।
Lordships, ladyship, pardon. Am I audible, ladyship?
Yes, you're audible.
May it please the Honorable Court that the Council is appearing on the behalf of appellant in the present matter. The Council seeks permission of the bench to address this bench collectively as your ladyships.
You may proceed.
Much obliged, your ladyship. Your ladyship, the Council will be speaking for 15 minutes, in which he'll be dealing with issue 3, which pertains to whether the date of default changes based on facts or it is to be taken as the date of NPA, and issue 4, which strictly pertains to admission of the application despite an error in the date of default. Now the Council seeks permission of of the Honorable Bench to proceed with issue 3.
Okay.
Your ladyship, as issue 3 deliberates upon, the third issue requires a deep deliberation, as the framing of issue itself implies that the issue is of suggestive nature and asks for the consideration of the bench in the very case. While the IBC itself does not mention the date of NPA as the date of default, but multiple precedents have been established to suggest that the NPA as the date of default is a progressive step in the code. Master Circular of RBI, that is the Reserve Bank of India, regarding asset classifications defines NPA as an asset which ceases to generate income for the bank. And your ladyship, technically a loan is classified as NPA when the interest or the principal remain overdue for a period of more than 90 days in terms of loan. While the date of default and the date of NPA are distinct, the Council does agree to the contention. But the NPA declaration provides the evidence that the default has occurred. And courts have noted that the date of default usually precedes the date of NPA. Still, NPA classification is the clearest documentary evidence default, as it is undertaken following strict RBI norms. Therefore, the NPA date is not an optional or discretionary date. It is the first formal, objective, industry standardized recognition of the borrower's inability to pay, your ladyship. The common criteria for determining the date of default is to ascertain the date on which the corporate debtor had amounted the classified as a non-performing asset. This was the view that was taken by the same honorable court in Babulal Vardhar G. Gurjar versus Veer Gurjar Aluminium Private Limited. And court observed that the date on which the loan classified is NPA should ordinarily be considered as the date of default for the initiation of CIRP proceedings, your ladyships. Moreover, your ladyships, in the case of financial creditor, that is Milind Kashiram Jadhav versus State Bank of India, the Honorable NCLAT itself observed that corporate debtors account was classified as NPA, and irrespective of the partial payments that were made by the corporate debtor, your ladyship. Pardon me, your leadership, you were not visible. That's why.
You can continue.
Okay.
No problem.
Moreover, the classification of NPA overrides any further step, including the issuance of demand notice and regard as the date of default. In Dena Bank versus Shiv Kumar Reddy, your leadership, the Supreme Court has held that date of default should be considered as the date of NPA, and any subsequent acknowledgement merely extends the limitation period, and that does not shift the date of default. The acknowledgement may extend the limitation, but it does not shift the date of default. And this was a three judgment judgment, your leaderships. Moreover, your leadership, the major technical or procedural aspect of considering NPA as a date of default is the fact that under a code, default is defined as when any part of the principal or interest remains unpaid, while NPA only occurs after 90 days of such defaults. Now, in such circumstances, your leadership, this is a progressive step, as banks do not merely treat NPA due to non-existent of some deficiencies which are temporary in nature, rather only classify a issue as NPA when it is clear that the corporate debtor's inability to pay your leadership. Moreover, your leadership, it can help the court to settle the dust of limitation period, as the date of NPA will be considered for the calculation of NPA, a limitation period of leadership. Now, this all step shows why NPA should be taken up as a date of default, especially in bank matters, and even NCLAT and an Honorable Supreme Court has been actively engaging in this context, your leadership. But this is leadership satisfied, so that the council moves to issue number 4, or?
Yes.
Thank you so much, your leadership. Your leadership, the fourth issue is whether or not a case can be admitted if the default has occurred and the application is within the limitation despite an error in the date of default. Now, your leadership, my co-counsel having already established through issue 1 and issue 2 that the second application is not explicitly barred by the code. Now, your leadership, just to clarify that although the provisions of Limitation Act were made applicable to the IBC proceedings by the introduction of section 233A, hence the period of limitation would be 3 years from the date of default as per section 137 of the Limitation Act, your leadership. As the account was classified NPA on 1/4/2014 and subsequent letters were issued on the part of corporate data on 1/7/2014, 1/1/2017, and these all written acknowledgements have kept the date alive. And even the factual metrics and issue itself suggest that the question of limitation does not even arise in this present case, your leadership. Now, having cleared the clouds over the limitation, now in the present case, the question arises whether a case can be admitted if the default has occurred and the application is well within the limitation despite an error in the date of default, your leadership. Your leadership, the counsel for the appellant does agree to the contention that the date of default in the earlier application was 1/5/2020, which was erroneously placed. But as held in para 22 of the DB Power Limited case, that the mere error in the date of default in the previous application is a technical and procedural mistake and does not involve going into the merits of the case, your leadership. The case had to be heard on merits, and the court or the adjudicating authority can itself arrive on the actual default and the date of default after hearing the case on merits, your leadership. Moreover, your leaderships, NCLAT and adjudicating authority took a misplaced view of application of section 10A to dismiss the petition of the appellant, your leadership. And the counsel for the appellant has several grounds to submit so. Firstly, your leadership, the recitals to the ordinance of section 10A reads, whereas a nationwide lockdown is enforced due to COVID-19, which has added to the disruption of the normal business operation. Here, your leadership, the word normal business operation has to be taken into consideration. The legislative intent of the act is quite ocular, that section 10A only intended to cover those business operations which got genuinely hit by COVID-19. Moreover, your leadership, the ordinance in its explanation part specifically mentions that the provisions of section 10A won't apply on the default committed before March 2020. Moreover to that, leadership, para 6 and para 7 of the proposition itself says that section 10A was introduced to protect the companies which genuinely incurred losses due to the pandemic. Now, in the present case, your leadership, the corporate debtor has defaulted since 2014, which is much prior to the 10A period, that is March 2020. And subsequent letters issued by the corporate debtor in 2022 seeking OTS justifies the continuation of the debt and the liability on the part of the corporate debtor. Now, your leadership, to support this view, the council would like to cite the precedent of the Raghavendra Joshi versus Axis Bank Limited. In the Raghavendra Joshi, the Axis Bank Limited, it was vehemently contended by the appellant that the application was barred by Section 10A because the OTS proposals were given in March 2020. But Honorable NCLAT nullified this contention and relied on the legislative intent of the Act, your leadership, and held that Section 10A never intended to cover the default which is continuing before 10A period, rather was brought on to help corporate debtors suffer the default on account of COVID-19, your leadership. Since there is a categorical default by the corporate debtor prior to Section 10A period and subsequent to Section 10A period, your leadership, the question of attraction of Section 10A does not even apply. Now, your leadership, the counsel for the respondents might argue that the default is not under the original debt, rather it is under the restructured OTS. But it has been held in many judgments of the NCLAT, your leadership, including the Mausami Bhattacharya versus Jumbo Chemicals, that the OTS is not a novation to the contract under the Indian Contract Act, under Section 62 of the Indian Contract Act. Rather, it is the continuation of the same default, your leadership. Now, your leadership, the counsel for the respondent might also argue that enabling application under 10A period would change the nature of the case. Now, your leadership, for this I would like to cite an example, or sorry, cite a precedent, your leadership, for the that is Narayan Mangal versus Vatsalya Builders, where your leadership, it is a prime example of how adjudicating authority and NCLATs have laid precedents relating to Section 10A cases. In above cited case, your leadership, the said amount of 1 crore to initiate the insolvency proceedings under Section 7 of the code was fulfilled by adding up the interest accrued in the 10A period, your leadership. The NCLAT dismissed the application of the corporate of the financial creditor, but your leadership, the same NCLAT reversed the appeal and relied on the Raghavendra Joshi as well as this Vishal Agarwal case and said if the default is committed before 10A period, then it will not be barred by Section 10A. But this, your leadership, fundamentally altered the nature of the dispute, where the dispute become non-admissible to completely admissible, and the financial creditors were given their right to recovery, your leadership. Moreover, your leadership, that NCLAT and NCLT and Supreme Court have demonstrated time and again that facts, circumstances, and legislative intent of the Act has to be interpreted liberally while determining a dispute related to Section 10A. Hence, your leadership, merely because appellant has committed a procedural error, a mere procedural error while filing the date of default, it could not be the sole reason to nullify the loan recovery rights of the financial creditor when precedents, your leadership, strictly speaks otherwise. Hence, your leadership, just to conclude my arguments for issue 4, the council would simply say that if second application is not barred, your leadership, under Section 7, if the default has been committed prior to Section 10A period and subsequent to Section 10A period, your leadership, if the date of default is mere procedural, your leadership, and technical and does not involve going into the merits of the case, even the legislative intent of Section 10A speaks otherwise, your leadership, then, your leadership, there is no reason to debar the financial creditor of its right to recovery merely because, your leadership, a clerical error such as filing a date of default has been committed. This is my primary contention, your leadership, the submission to my leadership, that merely because a procedural lapse has been committed, it should not debar the financial creditor of its right to recovery. This would go against the principle of natural justice, your leadership, that a mere procedural or technical lapse is not letting a financial creditor to claim its own your debt, the own loan leadership that it has provided. This is the bare contention that the council wants to present before your leadership. Now, if your ladyship permits, the council would like to move towards the prayers.
Yes, yes.
Thank you so much, your ladyship. Your ladyship, in the light of the issues raised, arguments advanced, and the authorities cited, it is most humbly prayed on the behalf of appellant that the court may graciously be pleased to hold that the second application is not barred by the law, admit the case despite an error in the date of default, and thirdly, your ladyship, pass any order, direction, or relief that this honorable court may fit deem in the interest of justice, equality, and good conscience, your ladyship. The council rests its submission. The council is really obliged to argue before your ladyship.
The council on the side of respondent seeks permission for the submissions.
Okay, but your camera is not. Where are you? Yeah. Okay.
Yeah. The council seeks permission to address the bench as your ladyship.
You may proceed.
Much obliged. The council from the respondent side will be dealing with issue number 1 and issue number 2, and my co-counsel will be dealing with issue number 3 and 4, and will proceed with the prayer. Much obliged. The counsel for respondent contends the arguments as the application made under Section 7 is barred by law. There are three my ladyship, are you well versed with the facts of the case? Then the council seeks permission to continue with the arguments.
Continue with the arguments.
Okay. Much obliged, Your Honor. The application made under Section 7 is barred by law. There are three circumstances that have arisen. The application made in 2022 that was filed stating the date of default for 2020 is barred under Section 10A. Section 10A states, notwithstanding anything contained in Section 7, 9, and 10, no application for initiation of corporate insolvency resolution process of a corporate debtor shall be filed for any default arising on or after 25th March 2020 for a period of 6 months or such further period not exceeding 1 year from such date as may be notified in this behalf, provided that no application shall ever be filed for initiation of corporate insolvency resolution process of a corporate debtor for the said default occurring during the said period. For the removal of doubts, it is hereby clarified that the provisions of this section shall not apply to any default committed under the said sections before 25th of March 2020. This clearly means that the default that has occurred during these dates, an application for IBC cannot be made for those defaults. The appearance have in the application that had been rejected by the NCLT had stated the date if default as 1st of March 2014, which falls beyond the scope of Section 7 as barred by Section 10A of Section 10A. On rejection of the application by NCLT, an application in 2024 was made, changing the date of default to 2014. NCLT and NCLAT, respectively, had rejected the application righteously, stating that the date of default was changed on the whim and fancies of the financial creditor. This has been rightly stated that only when the application dated 2022 had been rejected, the financial creditor had changed the date of default to 2014 with the motive of misleading the NCLT and NCLAT. And now this honorable court, the state application is made for harassing the debtor and to extract money that lies beyond the scope. The claims are not viable, namely because even if the application was to be accepted, the date of default as mentioned for 2014 stands way beyond the limitation period and is barred by Article 137 of the Limitation Act. Also that the second application stands non-maintainable since it is barred by the principle of res judicata. Under Section 11 of the CPC 1908, which explains the principle of res judicata, it prevents a matter that has already been adjudicated by the competent court from being re-litigated between the same parties. Once an issue of fact or of law has been directly or substantially in issue in a former suit had been heard and finally decided, the same cannot be reopened in a subsequent proceeding. The application dated 2022 arose on the same cause of matter between the same parties and was dismissed by the Honorable NCLT on merits. The dismissal on merits forms the basis of judgment, and therefore the principle of res judicata applies here. This application, therefore, is not maintainable. In the case of K.N. Rajkumar versus Adarsh Build State Limited, NCLAT held Section 11 of CPC codifies this bar and applies equally to insolvency matters. The NCLAT had uh, unequivocal, uh, unequivocally held the doctrine of res judicata applies to proceedings under the IBC. Therefore, applying the rule laid down in the judgment as well as Section 11 of CPC, the application stands debarred for filing. The council seeks permission to move with issue number 2.
Okay.
Much obliged, Your Ladyship. It is humbly submitted that under the IBC Code of 2016, Section 7 of the Act under which the financial creditor has filed the application states the requirements that have to met with Section 7, subsection 3, which states that the financial creditor shall, along with the application, furnish record of the default recorded with the information of utility or such other record or evidence of default as may be specified, referring to the Insolvency and Bankruptcy Application to Adjudicating Authority Rules 2016, where the Regulation 4 states the financial creditor shall provide the details through Form number 1 of the rules of the aforementioned Form number 1 under the head Particulars of Financial Debt, that is Part 4 of the form. Entry of 2 specifically states that amounts claimed to be in default and the date on which the default occurred has to be mentioned. Until and unless such details are mentioned, the application cannot be submitted. The respondent respectfully submits that mentioning the date of default is mandatory under the Insolvency and Bankruptcy Code of 2016. As default is the trigger for initiating proceedings under Section 7, insolvency cannot be invoked without proof. The code requires proof that a default has occurred, and such proof necessarily demands a specific date from which the non-payment began. A default without a date is legally incomplete because the adjudicating authority cannot determine whether the petition is maintainable or barred by limitation. The 3-year limitation period under the Limitation Act begins from the date of default, and therefore, unless the date is clearly and consistently pleaded, the court cannot ascertain whether the application is within the limitation or suffers from statutory time bar. The default date is hence not a procedural formality, but a substantive requirement that controls the very maintainability of the proceedings. The financial creditor first filed a section and under Section 7 petition on 1st of February 2022, while expressly mentioning 1st of May 2020 as the date of default. Since this date fell within the suspension period introduced through Section 10A during the COVID-19 pandemic period, the petition stood barred by operation of law and was accordingly dismissed by the NCLT, with the NCLAT affirming the same. Instead of accepting the legal consequence of the default date initially pleaded, the creditor later filed a second pleading under Section 7 application in 2024, this time altering the default date to 1st of April 2014, solely to escape the statutory bar of Section 10A. Such shifting of dates is not a correction, but an alteration of the claim, and thereby explains why a fixed default date is mandatory. If default dates were flexible, creditors could modify them at convenience to bypass limitation period or special statutory protections, which should erode the certainty, discipline, and finality intended under the IBC. Therefore, the respondent submits the date default forms the backbone of Section 7 proceeding. It governs limitation applicability of Section 10A jurisdiction, NCLT, and the very right to trigger CIRP. A petition without precise, consistent default date is consequently defective, and its score cannot be entertained. In the present matter, the financial creditor's inconsistent and strategically shifting readings regarding default further demonstrate why mandatory disclosure of the default date is essential. Within the scheme of the code, a case built on a certain foundation cannot cannot sustain insolvency proceedings, and therefore the dismissal by NCLAT and NCLT stands justified. It was an honor arguing before this honorable court. Now further my co-counsel would be arguing with issue number 3 and 4.
Okay.
May it please your lordship, the respondent submits that the limitation has expired long and the appellant cannot rewrite the default date to manufacture jurisdiction in issue number 3. Before entering the law, your ladyship, the council would like to draw your attention to the timeline itself that answers both the issues. Your ladyship, the corporate debtors account was classified as non-performing asset on 1st April 2014. This is the first and only date of default. Your lordship, between 2014 and 2020, the corporate debtor addressed multiple letters seeking restructuring and settlements. Your lordship, we even see an one-time settlement was sanctioned on 1st February 2020 and cancelled on 1st Feb 2020, which falls squarely within the section 10A, that is the COVID suspension period. Your lordship, the financial creditor then filed its first section 7 application on 1st February 2022, which was dismissed. A second section 7 application was filed on 1st January 2024, and again we see it was dismissed. So your lordship, the present appeal arises out of this repeated attempt, where we see that the timeline makes one thing abundantly clear, that the financial creditor just slept on its right for nearly a decade and is now attempting to revise a long extinguished claim to repeatedly altering the date of default.
Okay.
Your ladyship, we even see that that the IBC, the date of the default, is not flexible. It does not move out with OTS negotiation, restructuring request, or creditor strategy. It happens once on the first missed payment and never again. This flows directly from section 3 subsection 12 of the IBC, which defines default as non-payment of debt when due and payable. Once the non-payment occurs, default is crystallized. It cannot be reset, extended, or redated. So here, your lordship, the council has backed it by some Supreme Court precedents to make the law crystal clear. Here, in the case Lakshmi Pad Surana 2021 8 SCC 481, here the court held that it triggers for limitation under the IBC is at the first date of default. In the following case, Ramesh Kayam 2021, we see that the court held even during the COVID suspension period, including the settlement failures, cannot generate a fresh default. Taken together, your ladyship, the law is settled. Default occurs once and nothing thereafter can change it. Your ladyship, further we see that now a well settled position that settlement discussion, restructuring request, or OTS proposals do not amount to a fresh default, because this has been made clear by the NCLAT in SLB Welfare Foundation versus Union of India. It said that the default is a fixed event and cannot be redated and suit limitation or in its convenience. Therefore, the OTS in 2020, OTS cancellation in 2020, OTS letter in 17, 18, 19, 21, and 22 do not change the default date from 2014. So there are mere negotiation, not fresh breaches, your ladyship. Further, your ladyship, we see in banking cases, the non-performing assets date is not most accurate and reliable reflection in its first default. Because, your ladyship, it is based on the statutory RBI norms. It is consistent across all banks. It marks the point where repayment ceased entirely. Your ladyship, thus the court consistently accepts the non-performing asset date as the true date of the default unless shown otherwise. Your ladyship, here we see on the 1st April 2014 is undisputed as a non-performing asset. Thus, this is the only valid default date. Everything else is merely subsequent communication. Your ladyship, the respondent, we submit that the date of default does not change based on the circumstances later corresponds. It remains first missed payment here, the non-performing asset, that is 1st April 2014. Therefore, the appellant shifting the default dates is legally impermissible and cannot form the basics of the fresh Section 7 application. If the ladyship is if the council would seek permission to move on to issue number 4.
Okay.
Much obliged, your ladyship. The counsel for the respondent on issue 4 submits that a Section 7 application cannot be admitted when the financial creditor itself has pleaded an incorrect or contradictory date of default. Under the IBC, the date of default is the jurisdictional foundation. If the foundation is defective, the entire proceeding collapses, your ladyship. Here we see that under the IBC, your ladyship, the tribunal adjudicates on the basis of the date of default pleaded in part 4 of the Section 7 application. Your ladyship, we see that the tribunal adjudicates on the basis of the date of the default pleaded in part 4 of the Section 7 application, where if that date is wrong, contradictory or manipulated, the entire petition becomes jurisdictionally defective. Your ladyship, the creditor cannot say, ignore what we pleaded earlier. The real default was different. This would destroy certainty in insolvency proceeding. Your ladyship, moving ahead, we see that the records itself speaks, because in first Section 7 application that was filed on 2022, the default pleaded on 1st May 2020, that this date was the cornerstone of their entire case. It conveniently avoided the limitation issues. The NCLT evaluated this date applied under Section 10A and dismissed the petition. Your ladyship, second Section 7 application in 2024, we see here that the default pleaded on 1st April 2014. Now, after losing, the appellant switches on the non-performing asset date, not because it is the truth, but because it helps them avoid the Section 10A bar. Your lordship, this is not correction. This is reconstruction. This is reinvention. This is an attempt to manufacture jurisdiction. Moving ahead, your lordship, the principal was warned against the Swiss ribbons, which emphasizes the integrity of pleadings under the IBC. Your ladyship, now we claim in this memorial that earlier the date of default mentioned in the first Section 7 application dated 1st May 2020 was merely a technical error. The appellant have mentioned this. Your lordship, the plea of the technical clerical error is an afterthought and deserves outright rejection. If it were truly a clerical error, the NCLT would have not dismissed it first in the Section 7 on the mentability. We see the NCLT applied its judicial mind to date pleaded by appellant itself. It examined Section 10A limitation and maintainability based on that very date. Your ladyship, it gave a very reasoned dismissal, because we see it is a very deliberate pleading that the creditor relied on the litigation advantages. Not after losing, the creditors seek to replace it, revise it, and erase its consequences. So, your ladyship, this is legally impermissible, because here we see that there is no technical error because, your ladyship, a technical error is a typo, and here the creditor selected a date that avoided limitation and section 10A. The NCLT dismissed the petition on that date, meaning it was treated as a conscious pleading and not a mistake, your ladyship. Moving ahead, your ladyship, we see the IBC is a default based on regime, not a debt based regime. Even if debt exists, the petition cannot be admitted unless default is correctly pleaded and proved. Your ladyship, this court in BK Educational Service, it held that limitation begins from the date of default and not the creditor must plead this date correctly. Similarly, in the case SLB Welfare Foundation, the NCLT held that default is a fixed event. It cannot be redated later for convenience. Thus, your ladyship, even if a different date might fit better, the court cannot adopt it unless it was pleaded. So here, your ladyship, the jurisdiction under the IBC cannot reset on assumptions, hypotheticals, or what the creditor should have pleaded. It must rest strictly on what the creditor actually pleaded, your ladyship. Moving ahead, this case is a classic example of procedural manipulation. We see in 2022 they avoided limitation. In 2024 they avoided section 10A. So the respondent's position is simple and consistent, that the date of default is fixed. It cannot be rewritten to escape statutory bars. Permitting such shifting dates would repeatedly it cannot be rewritten to escape statutory bars. Permitting such shifting dates would, your ladyship, make limitation meaningless, nullify the section 10A, encourage repeated figures and repeated filings, and undermine the sanity of IBC proceeding. This honorable court has repeatedly warned against abuse of process in insolvency matters. Your ladyship, the respondent humbly submits that the date of default is jurisdictional requirement. The appellant's contradictory dates render section 7 application fatality defective. Your ladyship, the plea of technical error is unbeatable, especially after the NCLT's reasons dismissal. No section 7 petition can be admitted when the creditor's own pleadings are incoherent, inconsistent, and strategically altered. Therefore, despite any alleged error, the section 7 application was rightly dismissed and cannot be revived in appeal. The council would seek permission to move to the prayer.
Okay.
Much obliged, your lordship. In the light of the foregoing submissions, the respondent most respectfully prays this honorable court may please to dismiss the civil appeal filed by ABC Bank as untenable in law, uphold the well-reasoned judgment of this honorable NCLAT, declare that the dismissal of first section 7 petition in 2022 operates as res judicata, conclusively bearing any fresh or successive proceedings on the same debt, default, or cause of actions. Hold that section 7 application filed in 2024 is non-maintainable, being expressively prohibited under section 10A of Insolvency and Bankruptcy Code, and independently barred by limitation. Award cost in favor of respondent in view of repeated and vexatious attempts to relitigate settled issues, grant such orders or relief as this honorable court may deem fit in the interest of justice, commercial certainty, and the integrity of insolvency framework, and pass any order, direction, or relief that it may deem fit in the interest of justice, fairness, equity, and good conscience. It was an honor arguing before the ladyship. Thank you.